leaving instructions. People inquire about the best way to leave instructions regarding distribution of personal items or financial assets. So I think this is like, what do I just like tell everyone? I have an estate plan somewhere. Do I tell my kids I did an estate plan with, Preston at his law firm? Do I tell my kids to call my financial advisor? Do I give them a copy? Do I have to give beneficiaries a copy of the estate plan? Like what the heck? So I went and I think so again, it's like I went and met with the estate planning attorney, and now I have this 3-ring binder that's 500 pages thick or something.
Yeah.
And hopefully the kids find it or something, but I also don't really want to tell them that I got this done, because then they'll want to know what's in it and not. So now I'm just at a loss. What do I do now?
Yeah. And this is so, well, before I get to your question, let me just address what I picked up on as kind of a false assumption in that question.
Yeah.
And that is that you can just simply leave instructions for how you want your estate divided, and that will be functional as an estate plan. And I don't know, you're looking at the text. Maybe that's not what it says.
I'm talking about like like you have the estate plan done, right?
Yeah. Well, in case anyone I don't know.
It's good clarification.
Yeah, I feel like it's worth clarifying.
You can't just say Johnny gets the cars and Susie gets the jewelry,
because that's a common scenario where people think, well, my kids will do the right thing. If I just write down what I want to have happen, then the kids will just do the right thing. And that's how I understood the question as, how can I just leave instructions for the kids to do the right thing and make the right decisions? Yeah. The fact is that the kids all probably have a different idea of what it is that you want done, even if you told them expressly what it is that you want done. They all have a different idea. And even if they all were in agreement as to what you wanted done, they don't technically have the authority to make those distributions. They could do a side agreement, perhaps, but the court is going to distribute according to the state statutes if there is no valid estate plan in place.
Yeah. So, for example, say you have 4 kids, and little Johnny became a neurosurgeon that's and has wildly successful practices all over the country. And he's worth millions and millions of dollars. And mom and dad leave behind a meager $200,000. And the other 3 siblings always, maybe they have admirable careers, but they don't, have as much resources.
Yeah.
And so mom and dad didn't do the estate plan. State divides it up fourth. And Johnny says, hey, mom and dad helped me with medical school. And I always said, you don't have to leave me anything. And so I don't even need any of this.
Mm-hmm.
And the judge is still going to say, well, here's your check.
Right. Yeah. I mean, perhaps,
it's like
they can disclaim if they're so inclined.
Sure. But it's just an added layer of complexity, where now there's, anyways.
Yeah.
So and that happens. I feel like that happens more often than people care to admit, right? Like some kids are doing great and the parents just like, well, we helped them earlier on, right? Like you said earlier, kind of that mental accounting, like, well, maybe 2 kids we helped through college and the other 2 kids never went to college, and so we're kind of adjusting, present value and future values. And I think the other 2 kids that kind of have left now maybe should inherit more.
Mm-hmm.
Not saying anyone should do that. That's not my opinion or view. But if somebody was doing that, you want to make sure that you have it. You can't just tell all that. You can't, even if you sit all 4 kids down, like you're saying, and expressly say, you 2 are disinherited. You 2 get all of it, split it equally, like so plain and clear.
Mm-hmm.
That still is not good enough. What if they write it down on a paper? Like, okay, they type it up and I'm being very specific with my question here. They type it up in Microsoft Word, print it out, take it down to the bank and get it notarized, and say, these 2 are disinherited. These 2 split everything else.
Mm-hmm.
Is that good enough?
Depends on what state you live in, and maybe even what the judge had for breakfast that morning. And I'm serious. I mean, in Nevada, not a chance.
Yeah.
In Utah, maybe. And it's not clear cut. That's a risk. That's a risk to do it that way.
Big risk.
But
and I think people are thinking, well, it's my will. It's my thoughts. I put them on paper. I clearly signed it. And I had it notarized.
and this is where people get they misunderstand that leaving your assets to your children is not a constitutional right. It's not something that's endowed by our Creator and so on and so on. This is a product of statute that the state government has set out that allows people to do this. And because of that, the state can put whatever requirements they want. And so in a state like Nevada, the requirements are very strict. If you're going to write your own will, if it's not properly executed, witnessed, and so on, in accordance with the state statutes, there is another statute that says, well, you can do what's called a holographic will and write it down, but it's got to be in your own handwriting, and it's got to be signed, and it's got to be dated, and that counts. But if you don't do either of those things, let's say you type it up and you don't,
you kind of have components of both, but not either one fully.
Yeah, there's a high probability that is not going to cut muster, and most people are not looking up the state statute before they write a holographic will, or they kind of have an assumption on what they saw on TV about what constitutes a valid will, and so they write it down and sign it, and maybe even go to the bank and get it notarized, and without looking at the state statutes, and even sometimes the state statutes aren't clear, there's a chance that could be not valid. For example, if and I've had cases like this, somebody goes to get an estate plan done, and it's typed up, it's formal, it's witnessed, it checks all the boxes, it's a valid trust or will. But then the person whose will it is or trust goes in and starts lining things out and making changes.
Yeah.
The legal question is: are those changes valid? Will those changes be enforced? And that's a legal question that, depending on the size of the estate, can be literally $1 million question or more.
Cost you $1 million to get
yes,
answered.
That's what I mean by it. Yes.
Yeah.
Well, it probably won't cost $1 million to get through that litigation. Hopefully not. But
so you're Elvis Presley and die intestate with that kind of estate.
Yeah, but even on if an estate is worth enough, I mean, who gets the millions of dollars in the estate depends on whether those lined out items are enforceable, perhaps.
So there might be a lot of interest in dragging that out and paying attorneys a lot of money to argue that.
Right. There's enough ambiguity to create a case, for sure.
And now your money's funding, the attorney's next Mercedes instead of going to whatever it was that you wanted.
Yeah. Well, so let me answer the question that
the original question.
The original
okay,
question.
so you have your estate plan. Like, how do you get the instructions to let people know? Hey, I have an estate plan. I want people to know I have it, or I want them to be able to I want it to come out, right?
Yeah.
But oftentimes people don't want to just share their estate plan because, like maybe they don't want one of their kids to know they're disinherited,
right?
Or, or they are concerned that maybe if somebody got it, they could alter it.
Yeah. There's all kinds of reasons not to give your estate plan to anybody. And you've identified some of those. You don't want people relying on it, and in doing so, not making their own way in the world. You don't want anybody. Hopefully, nobody's trying to change it, but that'd
be an extreme case for sure.
That there's plenty of cases about that. And you don't want people fighting over it prematurely. You don't want people unduly influencing you. Mm-hmm. Suppose you're starting to lose capacity and you're more and more relying on your adult children. You don't want them to, or even the allegation that they've been unduly influencing you to make changes to your estate plan that benefit them. Yeah. There's a whole lot of reasons not to show anybody your particularly your will or your trust. But then, as has been identified here, there's also this scenario of, well, if nobody can find the estate plan or get to it, it doesn't do any good. And so if the estate plan is locked in a safe and nobody can access it, or if it's hidden somewhere in a book, I'm telling you, this happens.
Yeah.
Somebody left their holographic,
Well,
and
the old French dictionary with a revolver.
Right. This happens. Yeah. I've seen this happen in more than one occasion. Leave it somewhere where nobody will find it. Or if they do find it, then is this really a will? It looks more like a letter. There's all kinds of things. But yeah, so you've identified a good problem though, that, okay, if nobody can find it, it doesn't do any good. Mm-hmm. So I let people make their own choice on it. And a lot of it has to do with their own family dynamics. Some people have families where really seriously and sincerely everyone gets along and this is not going to be an issue. In that case, I say, it's up to you. Obviously up to you. And if you feel like it's you want to share it with your children, go for it. But other scenarios, and I'm not saying that if your family gets along, then you should share it. I'm just saying people may decide to do that, and I don't think it's the end of the world. But generally speaking, my advice would be, you don't have to share this with anybody, and you probably shouldn't, particularly the will and the trust. If you want to share your powers of attorney, perhaps you could do that, and that may be beneficial. You want to let those people know that you're asking them to take on that responsibility, and
you're giving them authorization. You can't make them do it.
Right, exactly. Yeah. And you want them to know that they're the one that's to be doing this, and you want them to know perhaps where that document is located, so that if they need it, they know where to get it, and then they can take it to the doctor and say, I'm the one that has the burden of making this decision. And so a good idea is typically, you can leave instructions somewhere as to where to find your estate plan. You can give out maybe the power of attorney. That I would say the healthcare, maybe the financial power of attorney. Maybe you can give a copy of that, or let them know where to find it if needed. Or you can, even if you leave a business card of the attorney that drafted it somewhere that's easily findable, people will often draw the conclusion, maybe this is the person who did the estate plan.